All right, I think we can get going now. Welcome everyone to our webinar on facing a lawsuit, some practical guidance for your business's next move. My name is Jodie Thomson. I'm a practice leader in the disputes team at LegalVision, and my co-host is Julia Cremona, a senior lawyer in our team. Before we begin, just a couple of quick housekeeping items. You will receive a recording and slides in your email after the webinar with some full details of everything that we've talked about. We're going to have a Q&A session at the end, so if you have any questions, you can submit them in the Q&A box and we will answer those at the end of the webinar. And we would really appreciate it if you could complete the feedback survey after the webinar and let us know how we've gone. Also, for the next 48 hours, you are eligible to receive a complimentary free consultation with LegalVision to discuss how we can help your business. So if you'd like to claim that, please complete the survey at the end of the webinar. So today we're going to be talking about what it looks like to go to court, whether you start the court process or somebody sues your business. We'll cover off a brief overview of the different types of courts and tribunals that you might land in if you're involved in a court proceeding, what that process looks like from beginning to end, some of the out-of-court options, the alternative dispute resolution options available throughout that process, what happens at the final hearing and trial, which is the main part of the court process, and a few tips on assessing your legal position and options along the way. And as I said, finishing with a Q&A section at the end. So Julia will speak first about the courts and tribunals and some of the different options that you might end up with if you are sued or if you're suing someone else.
Great, thanks, Jodie. So court cases can be brought in various different types of forums, so things like courts and tribunals, and there's various different types of courts and tribunals depending on the type of matter that you have, what the courts and tribunals have in terms of their powers, the amount in dispute and other sort of strategic considerations, which we'll deal with a bit later on. But we thought it'd be a good idea to give you an overview of what the court hierarchy or what the different types of courts and tribunals look like in Australia. So generally speaking, you usually have at the lowest level in the court system a local court, or sometimes they're known as magistrates' courts in other states and territories. Above that, we then have the district court, or sometimes known as the county court. And then we have the Supreme Court, which is the highest court in the state or the territory. There are also other specialised types of courts, like the Land and Environment Court, where they deal with, for example, environmental and planning laws. But generally speaking, that's what the court system looks like on a state or a territory level. We then have the federal level. For Australia, it's in its entirety. We have the Federal Circuit and Family Court of Australia, then the Federal Court, and then we have the High Court, which is the highest court in Australia. Like I said, there's also tribunals at both state and territory level. So they're very similar to courts, but they're generally less formal and usually have specific types of powers and responsibilities. But the main sorts of tribunals include various civil and administrative tribunals. So they're things that you might have heard of under the names NCAT, VCAT, ACAT, depending on where you find yourself or where your dispute is. But they generally deal with things like consumer disputes, residential tenancy disputes, retail lease disputes, building disputes and things like that. And then we also have from a federal level, the Administrative Appeals Tribunal, which deals with reviewing government type decisions. So some examples of the types of claims that we've seen that businesses deal with on a regular basis in court or tribunal are, for example, debt recovery. So where there's a person or a business that owes your business money, or you're trying to recover against them, or someone's trying to recover money owed against you. That might be money owed under a contract or some other form of arrangement. The other really common type of dispute that we see are contractual disputes. So where Those come up quite often if there's been a breach of contract, so someone has done things the way that they were supposed to or they've promised to under the contract, where people ask for a specific performance, which means, you know, they ask for an order to force a party to fulfill their obligations under the contract or to complete a particular task like doing a sale. And then we also see these scenarios where there are disputes about termination of contracts and where people claim damages as a result of breaches or termination of contracts. Another very often type of dispute that comes up and always comes up, but it was quite common in the COVID era, and it continues to be so, but leasing disputes. So where landlords and tenants have disputes between themselves, and that could be in relation to commercial leases or retail leases. And it's usually in relation to things like unpaid rent, where a tenant hasn't paid rent. If a lease is up for renewal or there are certain options that need to be exercised and there's a dispute about how that happens. And also make good obligations. So when a tenant is leaving a premises, what they need to do to put that premises in the position it was at the time they entered into the lease. Also, other types of disputes for corporate entities are disputes under the Corporations Act. So if there are disputes between directors and shareholders, any actions to wind up a company, or that is put it into liquidation, or claims for breaches of directors' duties, for example, they come up quite often too. And at a very sort of urgent level, we see what we call injunctions, which are urgent applications made by one party to restrain another party from doing something. So this could include things like freezing someone's assets, which means that, for example, someone's bank account is frozen, so to speak, which means that they can't use any of the money there. Can't go in and it can't go out. There might be other injunctions for things like preventing the use of confidential information or intellectual property as well. But like I said, the choice of which court or tribunal to go to, and even between different courts, what type of court to go to, it really depends on various factors. But the main sort of things that you would look at is the amount of money that's involved. Each court and tribunal has a limit in terms of a money limit or a claim limit in terms of what they can deal with. The type of dispute, sometimes there are subject matter limits, so specific courts and tribunals can only deal with specific matters. And there are also things to consider like the cost of going to court and tribunal or different types of courts and tribunals and the various powers that each of them have. And it's also a consideration from a strategic perspective as well, in terms of the process and how best certain forums suit your dispute or your claim. But it's always helpful to speak to a lawyer at the beginning of these claims to ensure that you are looking at either commencing or you're defending something in the right jurisdiction.
So now we're going to talk about what it actually looks like to be in a lawsuit or a court proceeding, whether or not you're the plaintiff or the applicant and you're commencing the proceeding or suing another party, or whether or not you're the defendant or the respondent and you've been served with some court documents. I should just say briefly that before court proceedings start, there's always some pre-litigation process. It might just be a letter of demand from a solicitor saying, pay this much money by this date, or we're going to issue court proceedings. Sometimes it might be a more prolonged exchange and negotiation settlements and so forth before court actually starts. But these court proceedings don't usually come out of the blue. There's usually something that's gone on beforehand that's either put you on notice of what the other party's claim is, or you've been preparing what your claim will be and trying to get it resolved before going to court. But court proceedings start with the plaintiff or the applicant filing documents outlining their claim and what relief they want, whether or not that's payment of money, certain actions to be taken or otherwise. The first document is usually called a statement of claim or an originating application. It can vary in different jurisdictions. There are very strict requirements for serving these documents. So first of all, you've got to draft it and put it together and then file it in the court registry. Different ways of doing that depending on which court. It's often done online these days. Then you get a stamped copy from the court with the court seal on it. That version has to be served on the other party. So if you're a defendant or a respondent, the first notice you will have of a court proceeding is being served those stamped court documents. If you're the plaintiff or the applicant, it's really important to serve those documents properly to make sure that your position is going to be valid and the proceedings can go ahead and you can seek judgment and take those other steps as you need. It's really important to serve them properly. The rules are that you need to serve individuals personally, and that usually means getting an expert who's called a process server to do that. But if the other party is a company, then you need to serve by posting to their registered address, which is the address that their company is registered on the ASIC register, and make sure that's done correctly. If you are a defendant or a respondent and you receive some court documents, you're served them. The most important thing is to make note of the time frame by which you have to respond. Again, it can vary a little between different jurisdictions. It's usually around 21 or 28 days. If you're served in a court that's in a different state than yours, there might be some extra time or some extra steps. But what's really important, and it will always tell you on that court document, usually up the top somewhere, what that timing is, that you make sure you either get legal advice as soon as possible or deal with it within that time frame. You might be prepared to pay the money, for example. Otherwise, the plaintiff or the applicant can seek a judgment against you without you having the opportunity to give your version of events, if that's the right thing to do. The other option that you have in terms of a response is a counterclaim. So, a defence is telling your version and perhaps disputing the matters that are set out in the claim. But similarly, you might have a cross-claim or a claim of your own against the other party who is suing you, so you can prepare a separate document. Most of these type of proceedings do really require legal advice. So in most cases, if you are served with court documents, we would recommend getting some legal advice to get some more advice on what the next steps might be. Once all the documents are filed, usually then an initial claim by the plaintiff and a response or a defence by the defendant, then things get started. The court will usually then start a timetable of things to happen between that point and the final hearing. The court might require the parties to come together for an initial appearance. It's usually an administrative appearance, just to find out what's going on, check all the right documents have been filed, and then set them some orders for what comes next, which might be discovery or document exchange, so that the parties have all the information that they need to make out their claim or defend their claim. One of the biggest stages in a hearing or preparing for a hearing is putting the evidence together. So the claim itself is quite bare bones. It just sets out each step of legal cause of action and what you're claiming and what you're seeking. But all of the detail is in the evidence. The evidence is proving your claim. Evidence can be from a layperson, which is a non-expert person, which is usually, for example, it might be the director of the company or the people who were directly involved in signing the contract, performing the contract, if it's a contract dispute. But there's also expert evidence. For example, in a construction dispute, the dispute might be over the quality of certain types of building work. The only way to prove whether or not that building work is correct or not is to get expert evidence, and that's additional evidence that's prepared. Usually what evidence looks like is a witness statement, or most often an affidavit. So it's a statement prepared, usually by lawyers in conjunction with the witness, really setting out all of the background and attaching all of the relevant documents so that there's full proof of what a party's claim is. It's quite a time-consuming part of the proceeding, and therefore quite expensive if you have lawyers assisting and working on an hourly rate basis, and can usually take quite a few months to get together and get finalised and filed in court. The other part of the process is settlement attempts. And even though you've got court proceedings going on, at any point in that process, from beginning to end, and when I say end, I mean literally it can be on the courtroom steps before the hearing starts, is quite a common time and place for matters to settle, is for parties to reach an out-of-court or a commercial settlement. And that means that they come to some agreement on a without prejudice basis, which means it's confidential and the matters that are discussed in settlement negotiations and the outcome of any settlement agreement reached is without prejudice, which means it can't be used in evidence in court. It's available to the parties to have those negotiations and try and settle things at any time. And what that might look like is, it might look like the parties or their lawyers sending settlement letters or offers between each other at the same time as the court proceedings are going on and various steps of the court proceedings. It might look like a mediation or a settlement conference that the court might organise. We'll talk about that a little bit more later on. But it's all part of looking at ways to resolve things without having to go to trial and to take up that time and expense that is involved in every court proceeding. That can go, as I said, that can go on at any time. Once the evidence and all of the document exchanges is finalised, the last stage of a court proceeding is the final hearing or trial itself. And that's what most people think of and understand when they see court proceedings. It's what we've been taught to see from watching TV and movies. There's usually months worth of work in the lead up to that hearing or trial. In Australia, a hearing or trial usually goes anywhere from 1 day to 3 or 5 days, and sometimes for much more complex matters, it might be over several weeks. And what goes on in that hearing or trial is each side has the opportunity to present their evidence to the court and to the judge and the other parties and make out their arguments. The witnesses give evidence, and that's usually talking through what's in their evidence, and they're cross-examined by the other party, who gets an opportunity to test their evidence and ask questions about it and try and poke holes in it usually. Once that's all finished, the judge delivers their judgment. Some judges will, in a shorter, less complex matter, might do that on the spot. Other judges might reserve their judgment, which means they will let the parties go at the end of the hearing or trial, and they'll deliver that judgment sometime later. It might be weeks or sometimes even months later. They might do that by sending it to them or posting it online, or they might actually call all the parties back in the courtroom to deliver that judgment in person. It depends on the court and the type of matter. Once the judgment is delivered, which is effectively which party is successful, then the judgment exists, and it might involve the winning party having orders that the other party pay them the money that they were claiming, or it might involve, depending on the type of matter, it might involve a company being wound up or one party having to perform certain steps or activities to do something. The plaintiff or the applicant can enforce that judgment. So if the other party doesn't pay the money or do what they need to do in accordance with the judgment, they can take steps to enforce that. We could do a whole separate webinar on what enforcement looks like, because unfortunately, parties don't tend to hand over money at the end of a court hearing or when a judgment is delivered. It can actually be a few more hoops to jump through before getting that money. But that might look like steps like garnishee orders or bankruptcy or winding up proceedings to actually force that other party to pay money if it's a financial judgment in that way. There is the option to appeal a judgment if you don't agree with what the judge finds. Appeals are quite complex. They're only available, and again, it differs in different jurisdictions and different courts, but generally there's got to be an error in law. and you really need your lawyers and usually a barrister to give advice about whether or not there has been an error and if there's any basis to appeal. But it can all take a lot longer. I should say this whole process can take a year or two. Most matters that we deal with and we see are not finalised in less than a year, and they can easily take longer than that. And the appeal process might take that long again. So if you're suing someone in the hope of getting something paid, you're not likely to see that money for quite a while, which is another reason we encourage parties to settle. It can get things resolved much more quickly.
So, like Jodie said, an important part of that whole process and every step of the way, including before even commencing court proceedings, it's important to think of different types of alternative dispute resolution options. So Jodie mentioned informal settlement conferences, but there are also other specific types of methods, and they can include things like mediation, an arbitration, or a conciliation. Usually people consider engaging in an alternative dispute resolution method in a way to try and lead to a faster or less expensive way to resolve a dispute. And it's also more confidential than going to court or to a final hearing. But just briefly, I'd like to just go through what each of these dispute resolution methods is. So the first is mediation. So this is a very common type of dispute resolution process. And it essentially is where an impartial third party called a mediator facilitates some settlement discussions between the parties in an attempt to help them reach a mutually acceptable settlement. So a mediator is typically someone like an experienced barrister or a former judge, or there are also people that are mediators for their entire career, so have a lot of experience in that area. So this process allows for a bit more flexibility and creativity in coming to some sort of a settlement, and gives the parties a bit more control in terms of what kind of settlement they can come to. So unlike a court, a mediator doesn't really make any decisions. The mediator also doesn't provide legal advice, but their role is to help the parties communicate with each other and explore some settlement options. So what this usually looks like is there's usually a joint session at the beginning of a mediation where all of the parties sit in a room together with the mediator, where the mediator explains the process and what is going to happen during the course of the mediation. And then the parties separate into separate rooms, usually, where the mediator comes back and forth between the rooms, conveys offers, discusses options with the parties, and attempts to help them reach some sort of a resolution. They are, like I said, this option is becoming increasingly popular, and a lot of the courts as well are requiring parties to attend a mediation before they go to a final hearing in an attempt to try and get the parties to resolve before going to the cost, time, and expense of court. The other option is an arbitration. So an arbitration is a form of dispute resolution where the parties have their dispute essentially decided by a neutral third party called an arbitrator. So here, this is a bit more of a formal process, more formal than a mediation or even a conciliation, which I'll get to. But the parties usually provide a lot of evidence and arguments to the arbitrator, who actually decides the outcome. So they usually provide a legally binding decision. While there are options to appeal this decision, they are quite limited as well. But arbitrations are usually more suitable where there's a very complicated dispute or a highly technical dispute, where the parties seek a bit more of a confidential process as well. But generally speaking, like a mediation, it is quicker and cheaper than a court. The final option for dispute resolution is a conciliation. So here we have a conciliator, which is the independent third party that tries to assist everyone to come to a settlement or a resolution. In conciliations, the conciliator is usually someone that has some sort of professional expertise in the subject matter. So, for example, it could be a complex construction dispute with 500 pages worth of contracts and various defects and various specific engineering questions or building questions. A lot of the time we see conciliations put into dispute resolution clauses in construction contracts, for example. But the conciliator's role is quite similar to a mediator in that they don't make a binding decision, but they are there to try and assist the parties to come to a resolution. A conciliator is a bit more active in their approach than a mediator, so they can do things like suggest potential solutions and guide the parties a bit more. But look, generally speaking, it's more suitable for these types of technical legal issues. So like I said, construction disputes, it could be employment or consumer-related disputes as well, or insurance claims sometimes find it helpful. And throughout all of this process, if the parties are able to come to some sort of an agreement, it's usually documented in a document called a deed of settlement or a settlement agreement sometimes, that lists everything that was agreed between the parties, and that's signed by them either at the end of the day or sometime in the future. You know, there are also circumstances where parties don't come to an agreement after even engaging in these dispute resolution processes, but they are still beneficial in that they can give everyone an idea of where each other is sitting in terms of legal position, strategy, and things like that. And it can also narrow down the issues in dispute. So that means there's less to dispute when it comes to an actual court proceeding. So just generally, there are some pros and cons of an alternative dispute resolution method as opposed to a court proceeding. So the pros can include things like they're faster compared to going to a hearing. So like Jodie said, you know, going to trial or the whole court process can be 1-2 years or sometimes even more depending on the complexity. But mediations, conciliations and arbitrations are usually set down for half a day or a full day. And if the parties are able to, you know, come to an agreement, then it sort of settles within that time frame. There are less costs and expenses in dispute resolution methods. The parties, like I said, have a bit more control over what the outcome can be. It's a bit more flexible and they're not subject to the decision of a judge. There's more privacy and confidentiality than in court, and you can preserve business relationships. And of course, the cons include things like, you know, there are obviously needs to compromise during these situations. There's limited ability to set legal precedents, and there's power imbalances as well.
So the final things that we just wanted to cover off to finish off our webinar today were a few more practical tips and some information about what it looks like going to trial. First of all, some court etiquette. Most people haven't been in court before until they land in there the first time. And again, it can be quite different than what you see on television. Address the judge as your honour. You will notice that everybody stands for the judge's entry and exit, and you'll certainly see that the legal parties are very formal when they speak to judges. Always request permission to approach the bench where the judge is sitting and follow any other court rules. And again, the lead from the legal parties in terms of answering any evidence and questions if you're actually on the stand. Always be professional, wear business attire. It's important to respect the courtroom and the legal process, and it can only benefit your position in terms of the way the judge is going to view your matter. We talked about a judgment and what that looks like. There can be different types of judgment. Sometimes it's a clear win for the plaintiff or the applicant in terms of everything that you claimed. You get ordered. In other times, the defendant or the respondent might win, and that might look like your claim being, or the plaintiff's claim being dismissed. Sometimes there's a mixed judgment. In many cases, the judge might find parts of each side's positions were believable or accepted, and the judgment might therefore be mixed. And again, they might reserve their decision to make a judgment at a later time. Just briefly on costs, and this is something that your solicitors will talk about a lot if you engage solicitors. Legal proceedings are very expensive if you have legal assistance. A ballpark figure that we often give clients, and it's really just a ballpark starting point, is about $100,000. Even in the lower courts and tribunals, it's difficult to get to a final hearing for much less than that, because whether or not the claim amount is $20,000 or $220,000, all of the legal steps and the time required is fairly similar. If you lose, it's quite common that the judge will order that you have to pay the other party's legal costs. There are some other complex issues that we won't get into in too much detail here about costs, but safe to say that you need to be aware there's a risk of issuing court proceedings or defending court proceedings, that if your position isn't strong, that you might get ordered to pay the other side's legal costs. And the court will, in terms of whether or not the court makes these type of orders, along with whether or not a party is successful, they will also look at that party's conduct throughout the hearing. Have you met deadlines? Have you complied with all of the obligations that the court has asked you to follow during the court process? And have you made a genuine attempt to settle the proceedings? The court really expects parties to have a good go at trying to reach an out-of-court settlement. It's not just an optional something that you might do along the side. It's very important to take these steps because it can impact at the end of the day whether or not the court makes some costs orders. There can be options for litigation funding or perhaps your insurer to cover your legal costs in a particular matter, but those things aren't a given. They're quite complex and difficult to obtain. So certainly look into them, but be prepared for legal proceedings to be a very expensive exercise. And last of all, just a few tips on what you need to do before you think about issuing legal proceedings or think about defending legal proceedings. And it's the first thing we talk to clients about when they call us with a dispute that might be already in court or going to court. And we refer to as, what's your legal position? And what that means is that based on whatever the relevant laws are in relation to your claim, what is your legal position? Do you owe that party money? Does that party owe you money? What do your contracts say? Has the party breached the contract? Who's right or wrong? Sometimes these things are a little bit grey and it's more a question of the lawyers assessing the risk. So we might talk about, if you start these legal proceedings, how strong is your claim? It's not always black and white, yes or no, but it might be, we might give you a 50-50 chance of being successful. So that's quite a risky proposition of going to court. In terms of being prepared for court once things get started, is what does that look like? It's all about documents in terms of lawyers getting prepared, understanding your claim and being able to give you the right advice. So as a party that's going into court, you need to have all of those documents ready, doing your homework at that end, reviewing everything, providing them to your lawyer, providing everything to your lawyer and being transparent with all of the information that you can. When it comes to engaging legal experts, when we say get legal advice, we usually mean in the first instance, contact a solicitor with experience in commercial disputes and litigation, which is what our team does. A lot of law firms and lawyers in Australia will be practicing in that area and can give you some advice. Most court proceedings are actually run by barristers, who we refer to as counsel. Barristers are lawyers, but they practice as barristers, and they're the experts essentially in going to court. They're experts in assessing evidence, preparing evidence, making arguments in court, and it is best to have that expert if you have a serious or a complex matter that's going to court. At every point throughout court, your barrister and solicitor will be reviewing materials, reviewing your position and the other side's position, and reassessing the strength of your case. Very often we might reassess that as it goes on, and what looked like a strong case at the very beginning, we might start to see some holes in it once we see the evidence come through or we see new information provided by the other side. So you really need to be prepared to take that advice as things go along and be aware that the position can change and that might affect advice around settlement. It's a very risky proposition, and it can be a very stressful business as well. So be aware of that before you dive in. That's the end of our webinar. I'll leave Julia to talk about a few final things before we get to our Q&As.
Thank you. Before we go into the questions, and we've received some questions during this webinar, and we've got a couple of pre-submitted questions that are fantastic. But before we go through them, you might find our publication useful in relation to a guide to resolving business disputes. You can download it in the resources tab or by scanning the QR code that appears on your screen. We also have an upcoming event that might be of interest to you. It is in relation to debt recovery, how to ensure your business is paid, happening on Thursday, the 1st of August at 11 a.m. And you can register via the link on the page. While you submit your final questions, we'd just like to take a minute to tell you about LegalVision's membership. So LegalVision members have unlimited access to a full team of over 100 specialist lawyers for all business needs or business as usual needs. It's like having your own in-house counsel for a fraction of the cost. So our team can assist with unlimited document drafting and reviewing of business contracts, unlimited legal advice, consultations, trademark registrations, and options to purchase extra credit towards complex matters. If you'd like to learn more about how membership can help you or your business, you can request a free consultation when the survey appears at the end of the webinar. So now we're going to go into some of your questions, and I'll just pop some up on the screen at the moment. So we've got a good question here about, can you represent yourself in court to save costs? Now, yes, you certainly can represent yourself in court. However, it does depend on how complex the matter is, how many issues come up, and how familiar you are with the court process. Court processes aren't something that people deal with on a day-to-day basis, so they can be quite daunting and difficult to deal with, which is why, as Jodie mentioned during the webinar, it is helpful to have someone with a lot of experience in it, like a lawyer or a barrister, to assist with it as well. Usually forums like a tribunal is usually very easy to self-represent yourself in, and that's the way that they're created, to assist you to self-represent. But higher courts, so we're thinking of Supreme Courts and federal courts and things like that, are much more complicated and complex. So it is definitely worthwhile, if it is a dispute that you can take on, getting legal advice from lawyers and barristers.
Another question we've got is, what are the costs associated with litigation? I referred to that briefly in one of my sections there. It does depend. Safe to say, legal proceedings are very expensive. If you have a legal assistance, you're looking at a ballpark, as I said, of around $100,000, but we regularly see matters that run for a year or two, and combined with some of the pre-litigation costs, which you might have engaged a lawyer for a couple of months with some initial letters to and fro, but costs can easily be in the several hundreds of thousands of dollars. And if you've been watching TV and some of the big defamation, the Bruce Lemon hearings, their legal costs are in the millions of dollars. So it's not unheard of for those types of figures to be there. And that obviously rules out a lot of people, but it's worth keeping in mind, again, as I said, if you lose and you might have a costs order to pay some of the other side's costs, that's very significant.
There's another question here that says, if a contract seems unfair, such as one that claims the entire 5-year subscription fee upon cancellation of services, does the court evaluate the fairness of the contract, or does this assessment occur before the plaintiff sues? Now, like Jodie said during the webinar, a lot of the times there's a lot of correspondence, so letters that happen between lawyers or between parties even before you go to court. Generally, the process is before you go to court, you would have assessed your legal position, obtained some legal advice from lawyers or barristers, and what usually happens is you would usually set out a letter to another party, and if you're arguing that certain clauses in a contract are unfair, you would set that out in the letter and see if you can resolve it or deal with it before going to court. If it's unable to be resolved, then you do take it to court, the relevant type of court that can deal with that matter, and it's dealt with throughout the process. So in terms of evaluating whether a contract term is fair or unfair, you can certainly have your legal position, but it's likely that the other side will have a different legal position or they'll push back as well. So this is then assessed by the courts. An interesting point to note in relation to unfair contract terms as an aside as well is courts or tribunals can also impose substantial penalties on businesses and individuals who have unfair contract terms in their standard form contracts. That's usually, we see it a lot in the news, and we would have seen it quite recently in terms of bigger types of organisations that deal with a lot of consumers that might have unfair contract terms, and they're usually the people that get these types of penalties.
There's a question here about legal professional privilege. So the question reads, very interested in how we can manage legal professional privilege when there are multiple ways our internal clients communicate with legal and each other. Example, email, Teams, chats. Does that include an education piece for business units? So this is quite relevant to being involved in court proceedings, because you might have to face this question of what communications or what documents are protected by legal professional privilege, and what might we need to disclose to the court or the other party as part of the discovery process, subpoena or any other related document request that can be part of court proceedings. So it is important when you're managing any internal communications or with third parties to consider what legal professional privilege is. And what that means is the privilege applies to communications where your lawyers are giving advice, and that advice is therefore confidential and protected, and you don't need to share that as part of that public court process. So some general advice that we can give is that as a general policy, managing privilege requires clear policies, training for employees. It's important to label communications as privileged and confidential if that's the case, providing advice. Limit distribution of any privileged material, store privileged documents separately and securely, and make sure you inform employees about that. Otherwise, won't deal with it too much in this webinar. It's slightly outside the scope of going to court, but it is worth being mindful of those matters so that you're able to provide the correct documents and details in any discovery request.
So just to add on to that, Jodie, we've also actually done a separate webinar previously on legal professional privilege. So if you'd like to watch that, you can look it up, or you can contact the team and get access to a link to watch that too. So just a final question before we wrap up. We've got a question about explaining briefly about how costs are awarded to the winning party at court. So this is a very sort of broad question, but just briefly speaking, it does depend on the situation. So the general rule is in courts is that the losing party pays the winning party's costs. Now that isn't always, and isn't usually 100% of the costs. So generally speaking, it's usually something like 60 to 70% that we've seen around that realm of costs. Sometimes there are certain situations where you can seek an order for more costs, so something closer to 90% roughly, but they happen in certain circumstances. Jo, did you have anything to add to that question?
Yeah, I would only add that a little bit, like I said before, when there's a judgment and the judge might order that one side pays the other side money. Unfortunately, there's no handing over of a cheque or cash at the end of the court proceeding. It's the same with costs. If the judge makes a costs order, which might be, right, defendant, you lost, you need to pay the other side's legal costs, then there's no money being handed over at that point. Unfortunately, it can actually be quite difficult to enforce that order and have those costs assessed. The other thing I would say is, when a court makes a cost order, they never mean all of your costs. You never get 100% of your costs back. I won't go into the detail about, there are two different types of costs orders, but broadly, you're only able to get somewhere between 60 and 80% of your costs back. And there are some separate steps to go through to ensure or to determine that those costs are reasonable and so forth. So unfortunately, it's not straightforward. You need to be prepared that you're not going to get back every cent, even if you are successful.
All right, well, that's all the time that we have for today. So apologies if we haven't answered your questions. If you do have any existing questions or you would like them answered, I can see that there are some questions about our membership. Our team will get in touch with you at the end of the webinar, or you can just submit your details in the survey at the end in relation to these questions. So while this is a free webinar, we do value your feedback on how we did today. So we ask that you please complete the 30-second survey at the end. Thank you very much for joining us.
Thanks, everyone.